All right, diving in today, a real head-scratcher of a case, this Lanes Group PLC versus Galliford Try Infrastructure Limited. You sent this over a whole stack of legal papers, and we're going to try to untangle it all, really see what we can learn from it. What makes a case like this so interesting?
Yeah. No, absolutely. It's not about getting bogged down in all the legal jargon. We want the big picture. What's really going on here? And, well, we've got this judgment from the Court of Appeal, Civil Division, December 21st, 2011.
Okay.
Quite a while back now. And it looks at appeals from the High Court, all about this process called adjudication. Right. So you got Lanes, they're a contractor doing railway work, and then Galliford, big construction company.
All right, so this Court of Appeal judgment kind of sets the stage for us.
Right.
What are the big questions we're trying to answer here?
Well, we're really looking at two main things. So first, did the adjudicator, the guy making this interim decision, did he actually have the power to do that? What they call jurisdiction in the legal world.
Okay, jurisdiction.
And second, was there anything about that decision that might make it seem unfair? Because maybe he was biased. This gets to the heart of how these construction disputes get sorted quickly, before they drag on for years in court.
Right. Makes sense. Jurisdiction and bias. Got it. So let's set the scene. What started this whole legal battle in the first place?
Right. So it all goes back to a subcontract. Galliford, main contractor, hired Lanes to replace the roof. It was a train maintenance depot up in Inverness. Network Rail Infrastructure owned the depot.
Okay.
The original contract. A little over £819,000, plus VAT. And they were using, standard terms, called the Blue Form from the Civil Engineering Contractors Association.
The Blue Form. So that's like the industry standard.
Yeah, it's kind of like a rule book for these construction contracts, how the project should be run, how you handle disagreements.
Okay, the rule book. So where did things go off track?
Well, first, there were delays. Lanes didn't actually start working until October 2008, way later than planned. And then in April 2009, Galliford, they terminated Lanes' employment on the project. Roof wasn't finished.
Right.
Lanes, they're saying this termination was wrong. They want about £2 million in damages.
Wow.
And, of course, Galliford. They've got their own claims against Lanes, about £2.7 million, saying the work wasn't done properly.
So both sides are claiming millions.
Yeah, classic construction dispute.
Yeah.
Back and forth.
So how do they try to sort this out?
Well, initially, they actually agreed to arbitration, which is, a more formal way to resolve disputes outside of court.
Mm-hmm.
But then Galliford decides, let's go for an adjudication award instead. Adjudication is much faster, like an interim decision just to keep things moving.
Okay.
It's pretty common in construction. Get a quick answer, keep the project going, or the cash flowing. Well, the bigger issues are still being figured out.
So Galliford wants the fast track. They want adjudication.
That's right.
And that's where Mr. Klein comes in.
Exactly. So Galliford starts the adjudication process.
Yeah.
They go to the Institution of Civil Engineers, the ICE. They appoint Mr. Howard Klein as the adjudicator. March 2010. He accepts. But now it gets interesting. Galliford's solicitors, their lawyers, they mistakenly thought Mr. Klein was biased against them.
Biased.
Yeah. Because of some disagreement they had with him in a completely different case.
There's nothing to do with this case.
Nope. And the Court of Appeal actually makes it clear later, no one is really suggesting Mr. Klein was actually biased.
Right.
But because of this misunderstanding, Galliford's lawyers, they mess up.
What'd they do?
They don't send in the paperwork, the referral documents, to Mr. Klein. They miss the deadline. These ICE rules are pretty strict about that. So what we see here is just wanting to adjudicate isn't the same as actually starting it properly.
They kind of dropped the ball then.
Right, big time. And, well, that's when Mr. Atkinson comes in.
So they try again.
They do. New adjudication, go back to the ICE, and this time, Mr. Daniel Atkinson is appointed.
Okay.
Lanes, not surprisingly, are not happy about this.
I bet.
They're saying, no, wait a minute. Mr. Atkinson has no right to be here. They're arguing he doesn't have jurisdiction because they still think Mr. Klein was validly appointed, even though, well, nothing really happened with him.
Okay.
They even try to get a court order to stop Mr. Atkinson. Doesn't work, at least not at this stage.
So Mr. Atkinson keeps going.
He does. Lanes actually misses the deadline for their response to Galliford's claims. And then in April 2011, Mr. Atkinson, he issues a document, calls it Preliminary Views and Findings of Fact. It's like his initial thoughts,
Okay.
onto the key points Galliford's raised. But here's the important thing. In the letter he sends with it, he explicitly says, this is not my final decision, just my current thinking.
Mm-hmm.
He's inviting both sides to send their comments. more arguments, by a certain date. It's like a draft.
Like a first draft of his opinion.
Exactly. Wants feedback.
So, not a final judgment.
Not at all. More like, here's what I'm thinking so far. Tell me what you think.
Okay.
Both Lanes and Galliford, they do send their responses to these preliminary views. Atkinson considers it all. And then, in May 2011, he issues his final decision. Lanes have to pay Galliford about £1.2 million.
Wow.
Which was actually later corrected to about $1.36 million plus his fees.
A lot of money.
Yeah.
So Lanes goes back to court, right?
They do.
To challenge this.
But this time, it's the Technology and Construction Court.
What are they arguing now?
Same two arguments. First, they're still saying Atkinson had no jurisdiction. Because Mr. Klein, remember, they say he's the only valid adjudicator.
Okay.
And second, they say Atkinson seems biased. They're pointing to the language he used in his preliminary view. Phrases like, I find and I hold.
Ah, so because of how he worded it.
Yeah. They're saying it sounds like he'd already made up his mind before hearing all of Lane's arguments.
Interesting. So the High Court, what did they think?
Well, the judge, Mr. Justice Aikenhead, he rules Atkinson did have jurisdiction.
Okay.
He basically says, look, just because Galliford didn't follow through with the first adjudication, that doesn't mean they lose their right to start another one for the same dispute.
Makes sense.
But then, on the bias point, he actually agrees with Lanes.
Oh.
Yeah, he thinks the way Atkinson wrote that preliminary review, it does give the impression that he already formed some strong opinions before he had all the information.
So a mixed decision.
Right. Jurisdiction for Galliford.
Yeah.
But apparent bias for Lanes. And that would have meant Atkinson's decision was invalid.
So what happens next?
Appeals, of course. Both sides go to the Court of Appeal. Lanes is appealing that jurisdiction finding, and Galliford is appealing the apparent bias finding.
Two big questions for the Court of Appeal to figure out.
Exactly.
Let's start with jurisdiction. What was Lane's argument there?
Okay, so Lanes, they're saying you only get one shot at this. You get one chance to start an adjudication with that initial notice. If you don't follow through, like Galliford with Mr. Klein, you lose your right to adjudicate that specific dispute, period. They basically saw it as Galliford trying to game the system.
Get a second bite at the apple.
Right.
That seems reasonable.
It was.
What did the Court of Appeal say?
Well, they admitted it's a tempting argument. It sounds fair, right? But they ultimately sided with Galliford.
Really? Why?
A couple of reasons. First, they said there's no rule that says you can't adjudicate a dispute later just because you messed up the first time, as long as you never actually served the referral.
So it's like you have to actually start the race to be disqualified?
Exactly. False start doesn't count.
Okay, so no one and done rule.
Right. Second, they pointed out that standard forms, like the blue form they were using and the ICE's procedures, even the scheme for construction contracts, which is like a backup set of rules, they all allow for starting adjudication again in certain situations.
So the rules actually anticipate that things might not always go smoothly the first time.
Yeah, exactly. Third, they made this very practical point. It would be a nightmare, they said, to try and figure out why someone didn't follow through. Was it an honest mistake? Or were they just trying to pick a different adjudicator they thought would be more favorable?
Yeah.
That kind of investigation would be a mess. Take forever. And that defeats the whole purpose of adjudication, right?
Yeah. Speed is key.
Right. And this is crucial. They reminded everyone that an adjudicator only gets his power, his jurisdiction, when he actually gets those referral documents.
Okay.
Since Mr. Klein never got those, he never really had the authority to make a decision.
So it's all about the formal referral. No referral, no jurisdiction. What about Lanes' argument that Galliford was just abusing the process?
The Court of Appeal addressed that head on. They looked back at a previous case. Basically said, look, this idea of abusing the process doesn't really apply to adjudication. Adjudication is meant to be fast, temporary. It's not the final battle. So they decided Galliford's actions were allowed under the rules. And Mr. Atkinson did have jurisdiction.
Okay, so Lanes loses on jurisdiction.
Yep.
Let's move on to apparent bias. That was the other big issue.
Right.
What were the legal principles the Court of Appeal looked at?
Well, they started with the basics. They established legal principles around bias, referenced a big case, Porter v. McGill.
Okay.
And from that case, the test they used was the fair-minded and informed observer test. Would someone, objective and reasonable, knowing all the facts, would they think there was a real possibility the decision-maker, Mr. Atkinson, was biased?
The fair-minded and informed observer test. That makes sense. So what about Atkinson's preliminary view had bothered the High Court judge?
Right. Well, Judge Waxman, he really zeroed in on the wording.
Yeah.
The phrases Atkinson used, like, I find, I hold, he thought that suggested Atkinson had made up his mind before even getting Lane's full side of the story.
Makes sense. But the Court of Appeal disagreed.
They did. They said it's all about context. You got to look at the context of that preliminary view.
Okay.
First, they pointed out the document itself clearly said these were preliminary views, not final decisions.
Right.
He even says he's not bound by them. Might change his mind.
So he put in a disclaimer.
Exactly. And on top of that, the email he sent with it, it also made it very clear. Provisional conclusions. Invited both sides to give their comments. The Court of Appeal, they made a distinction here. There's a big difference between making a final decision too early and just giving a provisional view.
Right.
Just to help the parties see where he at and maybe encourage them to provide more information. So they felt any fair-minded observer would understand this was just a preliminary assessment.
Not a done deal.
Right.
It sounds like he was trying to be open and transparent more than trying to hide anything.
Right. And they also considered the nature of adjudication itself.
Oh, right. How so?
They said adjudication, it's meant to be quick. It's a bit informal, right? Adjudicators have to deal with tons of information very quickly. So the courts, they don't like to overturn these adjudication decisions unless there's, like, really strong evidence of actual bias.
Yeah.
They said, look, adjudicators need some flexibility. They need to manage the process, and issuing preliminary views with a clear invitation for feedback. That can be a legitimate way to do that.
So because it's rough and ready, they have a little more leeway.
Right. As long as they consider all the arguments before making the final decision.
Okay, and the key question is?
Whether the adjudicator had already decided the outcome, and wasn't really open to being persuaded. The Court of Appeal, they didn't think that was the case here.
Okay, so we've covered both jurisdiction and apparent bias at the Court of Appeal. What happened in the end?
Well, they agreed with the High Court. Mr. Atkinson did have the power, the legal authority, to be the adjudicator. But they overturned the High Court's finding on bias. They said there was no apparent bias. So Galliford wins on that part of their appeal. Lane's appeal is unsuccessful. And so the Court of Appeal rules for Galliford. Yeah. They can enforce that payment that Mr. Atkinson ordered, plus interest.
So Galliford gets their money.
Yeah, in the end.
So what should we, the listeners, take away from all of this whole Lanes v. Galliford saga?
It really highlights a few key things about how construction disputes work. Firstly, it clarifies that you don't necessarily lose the right to adjudicate just because the first try didn't work out.
Right.
As long as you didn't actually serve the referral, you can still start the adjudication process. Second, the courts, they're going to take bias claims seriously, but they're also going to be realistic about how adjudication works.
Yeah.
It's fast-paced. So things like preliminary views, as long as they're clearly not the final word and there's an invitation for more arguments, they're not automatically seen as bias. Clear communication is key.
Being upfront is important.
It really is.
Anything else?
Oh, yeah. This case really shows how important it is to understand the specific procedures in your contracts.
Right.
And the laws that govern all of this, like the Housing Grants Construction and Regeneration Act from 1996 and the Scheme for Construction Contracts.
Right.
Know your rights and obligations.
Makes sense. Even for people who aren't in construction, this case is interesting, right?
Oh, absolutely. It shows you how legal disputes are handled, the importance of fair processes, this need to balance efficiency with fairness. Apparent bias, that's something that comes up all the time.
Yeah, it's not just a legal concept.
Not at all.
So for listeners who want to dig deeper, where should they start?
I'd say check out that Housing Grants, Construction and Regeneration Act from 1996 and the Scheme for Construction Contracts.
Okay.
To really understand the rules of adjudication. And there's a ton of other legal cases out there.
Yeah.
Dealing with adjudication and bias.
Interesting stuff.
It is.
One last thought. That initial misunderstanding about Mr. Klein, could that have been avoided?
Maybe.
With better communication. Maybe a better understanding of what bias really means in this context.
It's possible.
And how do we, as a society, balance the need for quick resolution, like with adjudication, with making sure the process is fair? It's a tough question.
Yeah. Something to think about.
Food for thought. Thanks for joining us on this deep dive.